talking to him a minute.
George, are you ready? I'm ready. Thank you. All right. Welcome to the Tuesday, October 17th, 2023 Town of Monroe Planning Board regular meeting. Noreen, would you please do the roll call attendance?
Bonnie Franson,
Here.
Jeff Manson,
Here.
Pat Shea's out, Nick Napoli,
Here.
Dylan Penn is out, Lou Rivera,
Here.
Robert Garstack. Lou will be covering for Dylan, and Robert will be covering for Pat.
I'd like to point out the fire exits. There are two in front of me to the back of the audience. Another is the main entry that you come in, and then there's another out this door to the patio. With that, could we please stand for the Pledge of Allegiance? I pledge allegiance. All right, first item on the agenda is a continued public hearing for Summercrest LLC. Do we have to pass a motion to reopen, or it's continued? Okay.
You're not on, if you can turn them on. I was getting ready to tell you that before you started talking. That's okay. There's a switch right on top. Just pull it towards you.
How's that? Does that work now? Good, thank
What
you.
about Jonathan's?
Jonathan DeJoy, attorney for the applicant.
Timothy Mitz for Summercrest LLC.
Before we open the public?
Nope, I don't think so.
Is there anyone here from the public that would like to speak to this application? It's Summercrest LLC. No? All right. Leave the public hearing and open until we're ready to make the decision, or can we close it at this point?
Close it at this point.
Okay. So I will make the motion that we close the public hearing for Summercrest LLC. May I have a second?
Second.
That was Lou. Noreen?
Nick Napoli,
Aye.
Jeff Manson,
Aye.
Bonnie Franson,
Aye.
Bob Garstack,
Aye.
Lou Rivera.
Aye.
Ashley, do you want to go through the resolution or anything you want to introduce before we?
Had adjourned the public hearing till tonight so that you could get the Orange County GML response, which you did receive, and that was a local determination from the planning department. And also, just briefly, I did want to comment, you did receive a letter at the last meeting or prior to the last meeting from a neighbor, an attorney representing one of the neighbors. So I just summarize, the issues that were raised there and just some comments on those. So it's really three main issues that the letter raised. The first question, whether it was an application. They gave a couple grounds for that. They said that the past 10 years chronology of use, occupancy, and ownership weren't included, so the applicant did submit what was available to them, and I believe to the extent, a full 10 years isn't provided, or if there's anything that is not in there, the board, it would be appropriate to waive that. You do have the authority to waive that to the extent necessary. Second was the construction drawings and material list. So they did give a material list. The construction drawings they did request a waiver for on the basis that it's not required by the building inspector. I also would think it would be appropriate to waive that as well. And then there was information about the windows and foundations that the board had requested to the extent those were changing. So I believe we did discuss this at the last meeting. Since they're not requesting that be part of this application, any certificate of appropriateness won't include any such changes. So in the event the building inspector determines that windows are being replaced and that it's subject to planning board historical review, then they'd have to return. The second item was regarding the use of the structures, and again, the planning board's not approving any use, and I think we've been detailed in our discussions there. The resolution does include some conditions to address the use or the future use of the structures as well. The last was a question about whether they were required to come before the planning board for the work, certain disturbance and clearing that was done for the utility lines on the property to date. So whether something requires historical review, that is a determination by the building inspector, so that wasn't previously referred to you, that scope of work. So related to that, I believe there was questions about, or complaints about flooding to the neighbor's property. Any kind of complaints or issues on those items should be directed to the building inspector. The neighbor can take that up with the building department.
Sean, anything you want to raise, or?
The applicants addressed my previous comments with regards to the application, so I have nothing further at this time.
Okay. Board members, questions you have? So we'll go through the resolution. So we have a resolution before us for resolution of conditional approval, certificates of appropriateness for Summercrest LLC. Summercrest has applied for approval of 13 C of As to allow alteration to roof, siding, other exterior elements of 13 structures. And then the structures themselves are listed. And then the properties that are affected are identified by tax map. Properties affected are in the RR1 zoning district of the town of Monroe. And then there's a recitation of all the plans and submissions that were made on behalf of the applicant. It almost appears that there's well, I think in some cases it's a repeat, but they were submitted several times, so they are repeated. Just a typo here that we picked up. This history, date of application is May 31st, 2023. Public hearing on this application was convened on September 19th, 2023, and October 17th, when it was closed. And then the type 2 action, which we had made a determination of previously. This was sent out to Orange County Planning Department for review and report under General Municipal Law 239M. And the Planning Department reported back that matter for local determination. Then we get into the waivers. So the resolution indicates that we will waive the requirements to provide construction drawings, as they're not necessary for the work proposed according to the building inspector. And then the 10 years chronology of use, occupancy, and ownership, to the extent not provided because that information has been scant. And then findings. The findings recite the section and the purposes of 5732 by which we review these applications. So planning board is considered, and I'll just scroll through this. You can all read that. And again, that's just what's recited from that section of the Monroe zoning chapter, correct?
Yes, the purpose is the ones that were applicable.
This particular application. Wording change there. So, actually, let me scroll back up.
Pardon me. For history, page 5, public hearing. Did we just close this public?
That was highlighted in
That
the
was
event,
highlighted as a plate to,
in case it didn't get closed.
exactly, so I take the highlight off now that it's been closed.
Right. So what we're looking at is a draft. So it's subject to change, and that yellow will be highlighted. All right, so findings, okay. Considered the following factors. I just wanted to go through 6, history, use, occupancy, and ownership of the property. And considering the use of the property, planning board notes applicant has not identified a proposed use of the regulated structures and has requested to obtain approval for the proposed alterations separate and apart from any approval of the use of the structures. Throughout the planning board's review process, applicant has acknowledged that it's proceeding at its own risk in this regard. In applying the principle of compatibility, planning board has considered the prior use of the structures as a summer bungalow community and finds that the proposed alterations finds the proposed alterations compatible in this context. Period, I guess, right? However, the planning board notes that such use is non-conforming and may no longer be permitted due to abandonment. Planning board thus determines to condition this approval on the applicant obtaining all necessary approvals for the reuse of any abandoned structures prior to any further issuance of building permits, i.e. permits for work other than that which is subject of the approved certificate of appropriateness or a certificate of occupancy for the same, unless the zoning board of appeals opines that such approvals are not otherwise required. So then our resolution of approval. A for Summercrest LLC. And then specific conditions. This proposal is limited to the proposed work identified in the table of proposed improvements, revised 8/10/2023, a copy of which is attached here too.
Actually gonna, because I think I've now modified, so that August document, it included all of the structures, not just the ones that are relevant, so it had denoted them by bold text, but rather than rely on that, I think it's confusing, so I realized I didn't modify this condition, but I did take out those other ones, so I've now modified the table to just include the ones that you're considering approval for. So I would just take out that language. It would just read, identified in the table of proposed improvements attached here too.
Okay, and that'll be the revised table.
Yes, that's in there.
Okay, so this piece in here is going to change?
It'll just say in the table of proposed improvements attached here too.
Okay.
No longer using.
For the 12 structures with the addresses of 27, 33, 35, 37, 39, 43, 47, 49, 51, 53, 55, and 57 Pinecrest Lane. This is limited to installation of the new roof shingles and siding and does not include any structural or other approvals required to install said roofing and siding. Any additional work that requires historical review by the planning board pursuant to section 57-32 of the town zoning code, including but not limited to replacement of windows and foundations to the extent the building inspector determines such work requires historical review by the planning board, shall not be commenced until a new application for a certificate of appropriateness is submitted and approved. To the extent the materials list includes an identification of window replacements, no such window shall be replaced without planning board approval. The colors of the proposed materials shall be as identified on the attached Summercrest LLC schedule of work as of July 26, 2023. To the extent such schedule of work includes 23 Pinecrest Lane, the proposed work for such building does not include any alterations to exterior features within the planning board's purview and thus is not being granted a certificate of appropriateness. All structures identified thereon as having asbestos siding shall not have new asbestos siding installed. Rather, the siding alterations authorized for such structures shall be limited to painting and or replacing shingles with shingles that are the same architecturally in terms of size and width and texture and not made of nor contain asbestos. Handling of the existing structure materials, including asbestos-containing materials, shall be conducted in accordance with all local, state, and federal regulations. This approval is limited to approval of 12 certificates of appropriateness and does not authorize any particular use of the structures. This approval is conditioned upon the applicant obtaining all requisite approvals for any future use of the abandoned structures, including but not limited to approval from the Planning Board and/or the Zoning Board of Appeals prior to the issuance of any further building permit, i.e. permit for work other than which is the subject of the approved certificate of appropriateness or certificate of occupancy for the use and occupancy of each structure. This approval shall not be construed as a determination or recognition that the structures of which certificates of appropriateness are granted can be legally used for any purpose. Applicant is proceeding at its own risk in repairing, altering structures that may not have a legal use under the zoning code. Any work done pursuant to this approval shall not give the applicant any vested rights or other rights to use the structures for any particular use. And then we have general conditions. So that will obtain the building permit applications, commence building permit, should say just building permits, not applications. Commencing and diligently pursue work authorized on the certificates of appropriateness through the completion of substantial construction within 30 months of the date of this approval. And these are all set forth in the zoning. Approval shall expire of any of the following if any of the following circumstances occur. Work authorized on the certificate is not commenced and diligently pursued through the completion of substantial construction within 30 months of the date of approval by the Planning Board, or within 30 months of the stamping and signing of a related site plan, whichever is later. Planning Board may. We don't have a site plan, correct?
30 days from,
Date of approval. I would take the other out. Can we just take this piece out? Because there wasn't a site plan. I think it's going to get confusing. Planning Board may, upon prior written request, at least 21 days before expiration, include a statement of justification, extend the time in which to exercise the permit for a maximum period. For a maximum, is it an additional period? One additional year?
ended by the planning board for a maximum period of 6 months and 1 calendar year respectfully, which 6 months was for the code section. It's 5732 sub M. So it says certificates of appropriateness and hardship for demolition expire 1 year from the date of approval. Certificates of appropriateness and hardship for alteration of new structure, that's the 30 months. And then upon prior written request, at least 21 days before expiration, the time to exercise the permit may be extended by the planning board for a maximum period of 6 months in the case of demolition, or 1 year for alteration. So it would be an additional 1 year. Maximum period.
So it's one of one addition. This approval is further conditioned upon all other approvals that are needed by operation of federal, state, or local laws and regulations, whether or not noted above in the specific conditions of this resolution, including or DEC, DOT, Department of Health, state or county, Monroe Town Board, compliance with New York State Uniform Fire Prevention Building Code. Approval is further conditioned upon the applicant delivering, prior to the signing of the plans or issuance of a building permit, proof in writing that all fees and expenses, engineering, planning, legal, and otherwise, owed to the town for all land use applications, planning board and or zoning board, in regard to this project or site, been fully paid. fully completed disclosure statement signed and either sworn to or affirmed by the applicant referenced above is on file with this board. In the event the right to develop this project is sold, assigned, or otherwise transferred, whether by transfer of the property or transfer of the management or operation or both, of the entity owning the right to develop to another entity, the transferring entity shall notify the town in writing, and any such succeeding entity must fully comply with this notification requirement before any work or other activity on the project shall be permitted to proceed, continue, or be completed. Certificates of appropriateness as approved by the planning board shall be binding upon the applicant and any subsequent owner of either parcel. No changes, erasures, modifications, revisions shall be made to the scope of work or materials after approval has been granted by the board, otherwise the certificates shall be deemed void. Any change from the scope of work and materials in the approved certificates of appropriateness shall require resubmission and reapproval by the planning board. No deviation from the plans, reports, or other documents that form the basis for this approval are effective unless and until an amendment to this approval is secured from the planning board in writing. Town of Monroe may stop work on this project and or revoke a building permit and or withhold a certificate of occupancy and or seek any other additional relief as authorized by law if any term or condition of this resolution is violated. A failure to comply with any such conditions in a timely manner shall result without further action in a lapsing of this approval. Okay. So, board members, any comments, questions, changes? No? 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 Okay. Anything else, Ashley? Sean? Okay. Noreen, you want to do roll call? For the approval that we just, yeah,
Can,
so you're ready?
can we ask one question to make it easier for this board? I understand the foundation issue being an issue, but can we, on the windows and doors, once the building's up and fixed, I can send you pictures of what the windows were and what the replacement windows and doors are, and upon giving you that, you can approve the windows and doors to be put on or not put on based on where I present, without having to go through the full process again. It doesn't hold this board up. But if the foundation's got to be done, I respect that. There's a lot more to doing a foundation and what the building can be lift up or not lift up. If you have to tear it down to the ground to rebuild it, all sorts of codes are involved in that. But I would just ask maybe, just say, okay, put the building up, I'll send you some pictures of what was and what's proposed in the windows and just amend this based on that. So it's only a couple windows on either building. Like we proposed the 2 walls, one on each building. Sean, you had pointed it out on number 37 and how it was dilapidated on one side. All we're going to do is fix that wall, put windows up. So that the rest of the windows in the building will stay. It's just that wall that gets new windows. And that way we're not wasting your time and making it more efficient, that I just come back to you, here's the wall, it's done, here's the proposed doors, here's the proposed window, and then you can just say yay or nay, and I'll adjust it.
I'm going to defer to our attorney because there's a process for an application, and if we're not approving it at this point in time, I think you have to go through that process. But
Yeah, so I think that's
I'm gonna
why the
defer to
question
you.
was raised whether, and I believe
because we
the
would have had
applicant's
to have
response
covered
was
it.
that they didn't require historical review based on your understanding from the building inspector. So if they don't, then they don't. It's just,
Oh, okay.
since that you're not
So-
requesting
We
it, the
don't
planning board
know
can't.
because you didn't request it. So he
Okay.
would have to
So this board
indicate that
wouldn't be able
it's,
to approve something that's not part of
Okay.
the,
So that would be Ben's decision, I assume?
yes.
Okay, all right, so Ben tells me whether it's got to be approved or not. Okay, no, but I'm just trying to make it easier as opposed to coming back for 2 windows and a door and doing this all over again. I don't think we want to. Thank you. Thank you very much.
so the table of proposed improvements, that's going to be updated to include just those structures and those improvements. And then this one, because there's one that just deals with structural, we're not including. The remainder are what we are including. So with that, would someone like to make a motion that we approve this resolution as amended?
I will.
May I have a second?
Second.
Noreen? Yes. Lou and Bob, or Bob and Lou. Aye?
Got it, sorry. Bonnie Franson,
Aye?
Jeff Manson,
Aye.
Nick Napoli,
Aye.
Lou Rivera,
Aye.
Robert Garstack.
Aye.
Thank you.
That the motion carries, and this will get filed. Do I have to sign the decision? I sign it? Okay. So I guess once it gets signed, it goes to Ben, who then
I'll
knows.
give him a copy.
Okay, and then if there's any explanation as to what was approved, he can always contact Sean. Okay.
Thank you for your time, much appreciated, folks, thank you.
Thank you.
All right. Next item on the agenda is returning projects, Barrett.
Turn it off when they got up?
You have
Did I
to
find-
push it toward, there you go, or
Testing?
pull it toward you. All right, do you want to give us an overview of where you are in the process?
I think we're pretty much there. Really not much new to add to the application. We resolved the rest of your professionals' comments, and we're ready to get this approved.
Comments?
Just one carryover from last time. There's a note number 4 on the plans that requires that the owner shall reside in the existing dwelling. I just asked that that be updated to state and shall reside in the dwelling unit until the accessory apartment use is terminated.
Oh, did we miss that?
So we don't have a comment memo for that?
I do, yep, I did.
Oh.
I did send one,
I have Cooper, is that Cooper?
Street, yeah.
Oh, 145 Cooper. Okay, I have it.
It's comment number 2. Otherwise, everything else had been addressed. County planning had local determination. You waived the public hearing, and I believe it's type 2.
Want to give us an overview of where we are?
Draft resolution for your consideration this evening.
Oh, resolution of approval, accessory apartment permit for Edward Barrett. And it's 1T? It just looks odd to me. I guess.
I think it's 2.
Okay, so
Yes.
globally, we'll change it to 2. Does anyone else feel like reading this? Sure.
Edward, nature of application, Edward Barrett has applied for approval of an accessory apartment permit allowing the conversion of 654 square feet of an existing single-family dwelling into an accessory apartment. The existing dwelling is 2,552 square feet gross floor area, and the proposed apartment will be located above the existing attached garage. The proposed apartment includes a 30 square foot vestibule entrance in the garage and a 624 square foot of apartment space above the garage. The property affected by this resolution is located at 145 Cooper Street and is shown on the tax maps in the town of Monroe as parcel 9-2-6. The zoning district, the property affected by this resolution, is located in the SR-15 Suburban Residential District, 15,000 square foot lot with central sewer of the town of Monroe. Plans. The accessory apartment permit materials considered consist of the following.
You don't have to read through all those.
Great. History.
Just list them 1 through 8. And you
One
can paraphrase if you like.
1 through 8, the history, the application was filed with the planning board on or about May 30th, 2023. Public hearing on this application was waived. For secra, it's a type of action. This matter constitutes a Type 2 action under the State Environmental Quality Review Act, inasmuch as the project embraces, in quotes, construction or expansion of a single-family, a two-family, or a three-family residence on an approved lot, end quote. 6 NYCRR, blah, 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 and/or reuse of a residential structure.
You could just
Go to the end?
summarize, yeah.
Thank you.
Do you want me to give you kind of a summary of the main points?
Yes.
So it is a type 2 action. It was referred to the county under GML. County responded that it was a local determination, so nothing further is needed there. And then you do have your findings beginning on the bottom of page 3. And these are the accessory apartment findings. They're found in Town Code Section 5744A. And on page 4, it just goes through the various findings, including that it is minimum habitable floor area, 450 square feet, and doesn't exceed 30% of the gross floor area. So that was one of the questions that we had clarified. The size of the apartment is 654 square feet, and the existing dwelling is 2,552 square feet. There's going to be no exterior alterations. I believe the only item that's being done is they're removing one door, a current entrance door into the garage, and then installing a new door that's going to lead into the accessory apartment. A lot of these findings on page 4 are incorporated as specific conditions because they do have requirements there relative to the accessory apartment, including that it could only have one bedroom, so any room, including any living room that's proposed, can't be used as a bedroom. And your specific conditions start on page 5.
Bob, you could read through, and if you want to, on page 5, starting with 1.
This approval is subject to a final engineering review. Plans won't be signed until the receipt of a letter from the planning board engineer. Prior to issuance of a building permit for the apartment, the applicants shall submit a revised owner affidavit. The principal single-family attached dwelling wherein everything has to be approved of satisfactory form by our attorney. The principal single-family detached dwelling wherein the accessory apartments to be located must be occupied at all times. It's only valid if it is occupied all times, single home. Town code. What? Sorry. 47, there should be no more than one accessory apartment in the building. It'll comply with all applicable requirements of Uniform Fire Prevention and Building Code. It shall be maintained in a neat and orderly manner. The turnaround area in the driveway shall not be construed as illegal parking. Each dwelling shall have its own separate independent bathroom and kitchen. Everything is the same. No exterior changes in expansion which may alter its foundation. The owner shall maintain the accessory apartment use in conformance with the requirements of Town Code Section 5744A and all applicable provisions of the Uniform Fire Prevention and Building Code. The permit shall be valid for a period of 1 year from the date that a certificate of occupancy is issued for the accessory apartment, and it shall be automatically renewed annually by the building inspector upon submission by the record owner of an annual certification for renewal to be provided by the town. Testing to the principal single-family dwelling is maintained as the owner's domicile, and payment of the renewal fee. The accessory apartment, this is outdoor fixtures, allows construction of only that which is shown on the plans identified above. No exterior things can be changed, no outdoor amenities can be done. The general conditions is conditioned upon the applicant submitting a complete building permit application to the Town of Monroe Building Department within 180 days of this approval. It's further conditioned upon the applicant delivering prior to issuance of the permit, proof in writing that all fees and expenses, engineering, planning, legal, and otherwise owed to the town for all land use. Everything's been paid. An entity disclosure statement signed and sworn to or affirmed by you, the applicant. Failure to comply with any condition in a timely manner shall result without further action in a lapsing of this approval. And that's what we've got.
Thank you.
You're welcome.
Any changes, any edits you see? Nope. You good? You're good? Sean, any last things? We're good?
Good.
Okay, and Ashley, no other changes? Then I'll make a motion that we approve the accessory dwelling unit for Edward Barrett at 145 Cooper Street. May I have a second?
Second.
Ooh, that was close. Who won it? Nick?
Bonnie Franson,
Aye?
Jeff Manson,
Aye.
Nick Napoli,
Aye.
Lou Rivera,
Aye.
Robert Garstack.
Aye.
Thank you. That, the motion carries, and the resolution will be signed and then provided to the building inspector. So you can move forward on the accessory apartment.
Great, thank you.
Thank you. Yeah, I'm going to promote a more interactive environment going forward. All right, next item on the agenda is DG Management.
Good, perfect timing.
Good evening.
Good evening, John Queenie with Lincoln Tully for the applicant. We're before you tonight with a request for an extension of the conditional final approval. We're being very cautious. I would ask the board if they would consider granting it till December. I don't think we'll need that long. I think we're at the end. We were at the health department this morning getting the plans and Mylars stamped, so it should be imminent, but we just wanted to be sure that we weren't going to expire.
So I think my only question is, do we have just general timeframes that we normally extend to? Or do we do it for a shorter time period if the applicant requests it?
So you do it for 90 days is
Okay.
the period, so, which is in line with the request for 3 months. So
And-
it would be,
And it's from the date that it would expire?
exactly, so it's set to expire November 7th, so it would be a motion to extend the conditional final subdivision approval for 90 days through February 5th, 2024. Is that right? Yeah, okay.
February 5th, 2024? Does that sound right? Yes? All right. So I think that's straightforward. I'll make the motion that we grant an extension of the final subdivision plan approval for the DG Realty Management Cluster subdivision to February 5th, 2024. May I have a second?
Second.
I think Jeff got that one.
Bonnie Franson,
Aye?
Jeff Manson,
Aye.
Nick Napoli,
Aye.
Lou Rivera,
Aye.
Robert Garstack.
That, the motion carries, so you have your extension.
Thank you.
You're welcome. And then are you here for the next?
Yes.
Okay, so we're here for Mountain View Shul. Is this another
This is a identical
identical
request.
extension?
Yes, just for longer.
All right, so, I know I. Actually, you submitted a while ago.
Yes. So yeah, again, the applicant is currently working with the Orange County Sewer District as well as the DC. We're still trying to get those outside approvals, and sewer. So
The sewer, both of them for
Yeah, so the
sewer?
way the sewer works, you go to the county sewer district first, they approve it, then it gets submitted to the DC, they approve it, and it goes back to county sewer, believe it or not, for reapproval.
And this is for an extension
For
or
this extension of the sewer main,
of the sewer main?
correct.
Okay.
And that's where we're currently at. So we would request the board consider a 6-month extension, or as long as that you could give in order to get that condition satisfied.
When was it approved in April, and what would that extend us
It
out to?
was approved April. Are requesting 6 months. Under your code, you could extend for one additional 180-day period. So it would be an extension for an additional 180 days, April 12th, 2024.
April 12th. Okay. So would someone like to make that motion?
So moved.
So the motion is to extend it 6 months to April 12th?
180 days.
180 days to April 12th, 2024. May I have a second?
Second.
Noreen? Aye.
Aye.
Napoli,
Aye.
Bill Rivera,
Aye.
Robert Garsta.
Aye.
With that, the motion carries.
Great. Thank you very much.
You're welcome.
Thank you.
All righty, so at this point, we just have minutes. Anything else you want to bring up, Ashley or Sean, before we move on? There is a member in the audience. Were you here for any particular application? No? Just listening in? Okay. All right, so the May 11th minutes, are those the one that you were out and Barbara put together? That was June?
Yeah. May 11th, I forgot to pull them up today. I don't
I
know why
actually
they're still
revised
hanging.
them. So I'm wondering if we approved them.
Yeah, I have to go back and look at the old agendas to see if I missed that one for coming off.
Yeah, so I had this revised.
Might have been done unless we were missing a member and we couldn't. I can't see that far.
But right now, it's the 1, 2, 3 of us, right?
I'll verify if we did or didn't do that one.
Okay. Other,
That one's the one that Barbara did?
this is the one that Barbara did, and I had asked to get a Word version so that I might amend it,
Okay.
and she didn't want to do that, good night, because
Night.
I think she was concerned about me editing it, even though we can revise it. So here, I have a question for you. So first of all, there's only 3 of us present, so we can't approve this anyway. How is the board docs created? This is like a verbatim transcript from the recording, isn't it?
It does give you a transcript on the side, and then you go through it and you change, you put the name, it doesn't say who's speaking.
So as
He did verbatim.
so can do I have the ability to do that myself, or is that something that's internal to the town government?
I honestly don't.
Oh, so
Can
you don't,
ask.
how do you do
I
it?
get it that way too, but
Oh,
I
you
don't
get it that
always
way.
do it verbatim.
But how do you?
Certain ones, if you look at like Monroe Commons, I have done verbatim because of everything that was going on. Parts of Summercrest have been verbatim.
But in other words, is there an application?
It's just board
that-
docs.
I go to the website, and I go to agendas and minutes, right? Go to the. So let's say,
They're all listed on the,
I go to. Sep- 14th. No, so my question is, how do you create that transcript?
so when you go into
Can I do it myself, or is that something only you do as an employee of the town? Are you able to do it?
I can't see the boxes on the bottom, I can't read them.
It says, view the agenda, download agenda as a PDF, print the agenda, watch video. Okay. All right.
The three of us can do it.
So then, what I would ask is for that particular meeting, would you please create the transcript?
Sure.
And then we have a Word document, and we can edit it. Okay? And that's it. All right, and then I think we got a couple of,
You got them, but they have not. The whole board didn't get them.
oh, they didn't? Okay.
You told me to send them to you first.
Yeah, I just got them on Friday.
I know.
Okay.
The one with Monroe Commons took forever.
So that one was 2 September, there were 3 September meetings.
No, there was 2 August, 3 August, 2 September.
Oh, so it was 3 August, okay.
August is done, September 14th is done. I finished it at 5 before.
Just give me then a list of what we may. And then just add them to the, agenda, so whether we get to them or not, they're there, so we know, and then they can drop off as we do them. Okay, board members, anything else you want to bring up?
Nothing here.
Nothing?
Do you want the Monroe? Sorry, my notebook hit the mic. Do you want a hard copy of the Monroe Commons DEIS? It's gonna come in a big binder. You want a hard copy of the final,
Or just digital?
or do you just want digital?
No, I'll take a digital, thank you.
Okay, and you wanted digital, and you three want hard copy. So the only one I don't know is Dylan, since he's out tonight. So I'm gonna say that if needed, could I get another one later on? I'll ask them. Because I don't want to make them printed if it's only gonna hang in my office. Because I'm already getting one to my office.
Okay.
Plus the 3 of you want them, Sean and Ashley.
I find that I like to mark up the document, the hard copy. I'm like old school that way. And so then if I have comments, I do it off of the hard copy. After I look at all my little notes and my, dog-eared pages and et cetera, et cetera. So that's just me. Just like the same thing with plans, and this is in my professional line too. I can look at maps digitally, but sometimes they're so detailed, you're just not seeing everything on a screen. Whereas if I open them up in front of me, these large maps, I can look at all the details and read them and see, and mark up or make comments on it. So it's just from the way I'm able to provide comments, I like to have hard copy, for me personally. But everybody's different. So, all right. All right, with that, if there's no other business, I will. Okay, I'll make a motion that we adjourn the meeting. May I have a second? Second. All in favor say aye.
Aye.
Any nays, any abstentions? Motion carries. Meeting adjourned. Thank you all.